Welcome everyone to our Monday Phelomex Cook IPR Colloquium. Today we're excited to have three interdisciplinary scholars. So Adam Pa is a clinical assistant professor of management and organization and the associate director of the Northwestern Institute on Complex Systems, NICO. And his research focuses on artificial intelligence, complexity, and computational analysis. And he's driven by the problems that are important for understanding human behavior, social interactions, and decision-making. He's done work on the law, gun violence and terrorism, and healthcare, among other topics. And on the legal front, which we're going to be hearing about today, he's involved in joint work along with faculty from 10 universities to develop the systematic content analysis of litigation events open knowledge network. The second presenter today is Sarath Sanga. He is an associate professor of law at Northwestern. He's also an economist by training. His area of expertise focuses on contract and corporate law, as well as topics more broadly on law and economics. And last but not least is our very own Rachel Davis Mersey. She is the Jesse H. Jones Centennial Professor in the School of Communication and Media and the Associate Dean of Research at the Moody College of Communication at the University of Texas, Austin. As we all know, she was previously a professor in Medill and a longtime IPR fellow. She's now an IPR faculty adjunct, and we're so excited to see her again today. Before becoming a professor, Rachel was also a reporter at the Arizona Republic. So she brings a very diverse viewpoint in terms of both the academic and the practical side of understanding the media. Her research explores a number of questions surrounding healthy media markets. She's the author of 2 books, Mobile Disruptions, which examines the state and opportunity of media innovations in the Gulf states, as well as Can Journalism Be Saved, which explores the local news community and kind of the community-driven initiatives surrounding it. Rachel is also a PI on the project we're going to be hearing about today, the systematic content analysis of litigation events. And the idea here is that they're going to be using artificial intelligence to bring transparency to court records. So without further ado, I'll turn it over to the 3 authors, and we're excited to hear your work today. And just a reminder to everyone to submit your questions through the Q&A.
Thank you so much, Laurel. It is truly an honor to be back with the IPR community for all the difficult times our communities are going through. I have to say, being able to be virtually connected to you has meant so much to me. As I see these names of people who I used to see on Monday when we were together pouring in today, it really warms my heart. So coming to you from Texas and really happy to be connected. I'm just going to get us started today and introduce sort of the problem statement related to the work that our team has been undertaking with the support of NSF, and hopefully frame it in a way where IPR colleagues and faculty can start thinking about some potential collaborations in this space. And the first is really to move to the next slide to focus on the value in open public government data. And for many audiences, we have to spend a ton of time talking about this, but I think as we think about the IPR community, it's really easy to say, we don't have to talk about this a lot because we know this is a community that understands this value. Beth and Kat's work demonstrating racial disparities in policing. On the next slide, Beth Tipton's work focused on giving researchers appropriate schools and directions for recruiting populations in their communities. Beth, I can't remember if this presentation was last year or the year before. Forgive me, time has started to mean a little less these days. And then finally, as all of us have seen, Diane's work with IPR Summer Research Assistant on a visualization tool to show weekly rates of food insecurity. So this is a community that knows the value. And what I want to spend the rest of my time focused on is really on the next slide, how different courts are. And so ultimately, the questions of equity are really not answered by courts without significant hand-coding labor and costs. So you'll see here on this slide a few questions that we're really not able to answer without significant human resources put to the problem. And that ultimately really framed how this team came together under the leadership of Dave Schwartz from the law school, who kind of set out some of these questions for us. And so on the next slide, it shows you how policy makers policy researchers and journalists currently access court records. It's through an electronic database called PACER. Well, I'm not going to show you a ton of slides about PACER. I'm going to show you the next one, which really shows how it works at the infrastructure. In media, we aim for frictionless infrastructure. I would call this a high friction infrastructure. And there's some more points on this slide to point out exactly why that is. First, there's a significant cost. So even though we're in an environment where we're not printing out pages, PACER still charges 10 cents per 54 lines of printed HTML. So every time you do a search, you're encumbering costs. The text itself is unsearchable. So while you can search by fields, you cannot search the open text to look for language that might help you better understand the details of a case. Information is significantly siloed. So for a layperson like me, I might ask a question about racial equity, but racial equity might exist in a lot of different types of cases. And to search those types of cases, I need to go into each silo to get them. And domain knowledge is not a sufficient solution. So while it's easy to say media researchers and journalists might struggle with this, what we've learned over the course of this work is that lawyers do as well, right? Legal researchers do as well. Well, they have tremendous domain knowledge. The challenge of working with the infrastructure of the system really becomes untenable. Finally, as you note on the next slide, courts are generally just hostile to being analyzed. I think there are a lot of power structures that are like this, but we're surprised to hear that from the courts because we think of courts as an open place. And in fact, courtrooms are open, but the records themselves remain really in the darkness of how we think about public records. So we're not able to address issues of inequality for the public benefit. That's really how this team came together. And I think you'll see on our next slide, the mission statement of this team, which is where I'm going to leave this slide to Sarath and to Adam, or this presentation. We're really focused on how do we bring transparency to the systems and processes of the US courts with a focus on fairness, efficiency, and accuracy. And that's a lot of where the interaction with policymakers and policy researchers comes to be. So Sarath, to you.
Thanks, Rachel. Hi, everyone. I'm Sarath Sanga. I study law and economics here at the law school. So let's talk about some of the applications of our project. And I want to briefly go through sort of the structure of the court system itself, as well as the structure of the court records that our team is assembling and cataloging. And then I want to give you a concrete example of a research project that we have conducted, which uses these records and is ongoing, which studies the inequality and themes of inequality as well as access to justice. So to make sense of the structure of the court records themselves and sort of what they can teach us, I think it might be worth spending just a minute thinking about the structure of the judicial system itself. So broadly speaking, our judicial system reflects the federal structure of government. We have one unified federal court system, which covers the territory of the United States. These are the courts of the United States government. And then we also have 50 separate state court systems, which are independently run, of course, by the governments of each of the 50 states. Now, these two courts are hearing very different types of cases, or the composition of cases that they hear is quite different. And that's because federal courts are courts of what's called limited jurisdiction, meaning in order to get into federal court, your claim has to fall under some kind of federal law, or alternatively, you can get into federal court if the parties to the lawsuits come from different states. States courts, on the other hand, are courts of what's called general jurisdiction, which just means that as a general matter, state courts are simply presumed to have jurisdiction over any case, whether it falls under state law or federal law. So the upshot of this jurisdictional difference is that the composition of the cases that we see in these two types of courts are going to be very different. The vast majority of criminal cases, for example, those are handled in state court systems. For a criminal case to go federal, it has to touch upon some federal statute like wire fraud or drug trafficking. On the civil side, pretty much any case involving the United States government as a party, either as a plaintiff or a defendant, is going to appear in federal court. The same goes for cases that are arising under federal statutes like patent cases and antitrust. So let's move to the next slide. And in principle, you might think it would be terrific to have court records from all state courts and all federal courts. But for now, our project, we're focusing on assembling federal court records. And this is mostly for practical purposes. The reason is that, of course, federal courts cover the entire country, and the system of cataloging federal court records, the PACER system, which Adam's going to talk more about later, even though it is a total mess, it turns out it's at least more uniform compared to the 50 separate systems of state court record keeping. So we're focusing on assembling and cataloging federal court records. Just a brief note about the structure of the federal courts, which perhaps you're familiar with. The federal court system has 3 levels. The lowest court where trials take place is called the district court. There are 94 of those. Each state has at least 1 district. Some larger states have more. So Illinois, for example, has 3 districts. Here in Chicago, we're located in the Northern District of Illinois. And each district has many judges. So our district has 22 judges, I believe, at last count. That's actually a lot of judges for a district, but it's because it includes the city of Chicago. The second tier, of course, are called the courts of appeals or the circuit courts. There are 13 of those. And each of the circuit courts contain a certain number of districts. So cases that are appealed from the Northern District of Illinois, for example, go to the 7th Circuit. And then finally, of course, there's the Supreme Court sitting at the apex, the court of final appeal. The Supreme Court, though, hears very few cases, something like 100 or so each year. And some of those are disposed of very quickly. It's very rare to even get a case to the Supreme Court. And that's because it has control over its docket. So this is the first main point here, is that the district courts and the appeals court, they have to hear whatever case comes their way. But the Supreme Court can decide on its own whether or not it wants to hear an appeal. About 300,000 cases are filed in federal district court each year. About 1 in 6 of those eventually get appealed to a circuit court, and something like 1 in 3,000 ever come before the Supreme Court. So on the next slide, I'll give you a sense of the data that we already have. So here's the federal court records that we already have assembled. It's about just over 450,000 cases filed in the district court. That's the trial court level. Most of these cases, about 80%, are civil cases. And the data we have, you can think about it as 2 distinct samples. The first sample is all cases filed in a single year in 2016. So any case filed in any district in federal court, we have that record. And the second sample is all cases filed right here in our home district of the Northern District of Illinois over a 8 or 9 year period. Our medium-term goal is to acquire the case records for all cases filed in all federal courts for all years available. So that means at least the last 10 years, and depending on the district, sometimes it might go even further back than that. So let's move to the next slide to take a closer look at the data. So what exactly is a court record? Well, we can think of our unit of observation, so to speak, as being at the lawsuit level. And each lawsuit has 2 types of records. You can think of it as 2 types. The first is what's called a docket report. And then the other records are the underlying document that a docket report references. So let's talk through briefly these 2 types. What's in a docket report? A docket report, you can essentially think about it as a title page and a table of contents. So it's a living document. It's constantly being updated as a lawsuit progresses from the filing to when it's from the initial complaint to when it's ultimately closed. Here's an example of a docket report. It's from case number at the top. You can see 116-CV-00011. The case was filed in the Southern District of Georgia, which includes the city of Augusta. At the top of the docket report, we see the title of the case. This one's Teasley versus Sellers. The judge that was assigned to this case, right under that, you see is Judge Hall. Sometimes cases are transferred to another judge for a variety of reasons. That happened in this case. And so we also see the judge that it was transferred to. In this case, it's what's called a magistrate judge. The case type, or sort of the subject matter, is also listed at the top, as well as along the left side, all of the parties in the suit and the attorneys that are representing these parties. Okay, so that's sort of the header of a docket report. On the next slide, we see what appears below that on the docket report. Below this, we find which you might think about as the meat of the case, so to speak. It's a list of all the events that occurred in the case. This table here is part of the docket report. It gives essentially two things. First, the date on which the relevant event occurred, and then after that, a brief description of that event. So sometimes the event is just a document that was filed by one of the parties or maybe filed by the judge. So the first event here that we see on that first line, it's a document filed by Teasley, who's filing a petition for habeas corpus. So it turns out the petitioner here, Teasley, had previously pled guilty in state court to aggravated assault and robbery. He got 20 years sentenced to prison. And the writ of habeas corpus, for those who aren't familiar, basically it's one of the principal mechanisms through which federal courts review unlawful detentions under state criminal law. So habeas petitions, as you might imagine, thus make up a very large part of federal courts' civil dockets. They're actually civil proceedings. Now you might ask yourself, what about that petition itself? The petition that was filed. That document is referenced here, but it's separate. It's an underlying document. And for most of our cases, we don't actually have those underlying documents. Because of this 10 cents per page business, acquiring them would turn out to cost a lot of money. So here I want to talk about sort of the downside of not having this, but then I think there's a bright side too. So the downside, of course, is that you kind of would like to have the underlying documents. It's one thing to have the table of contents, but golly, I want to see the contents, right? So it'd be great to have those. On the other side, though, I think there's a silver lining, and Rachel talked about sort of the high friction of these data. The upside is that the dockets themselves still contain a wealth of information, and more importantly, you can think about them as a really concise and thus extremely useful summary of all the things that are in the case. Sometimes these underlying documents can be hundreds or thousands of pages, which would be difficult to parse. So the docket report itself, you might imagine, sort of simplifies a lot of our job of parsing the text. Also, if you're familiar with some of the institutional details or the domain knowledge, as Rachel talked about, some of that can go a really long way to potentially extracting information about each case and to essentially reconstruct the case, even just from this table of contents. So let me give you an example. If you scroll down here to the 9th entry, that second blue arrow, on February 11th, 2016, it says the magistrate judge's report and recommendation. It goes on to say that the summary here tells us that Teasley's habeas petition was dismissed without prejudice. So that just means that Teasley could come back and try again, presuming he files the right papers. So suppose you're a criminologist and you were studying, for example, the determinants of habeas denials. Then you would know, even from just the docket report, that this wasn't so much a win or a loss for Teasley, but more of something like a draw for him. The court's saying he can come back later, and that's because it wasn't dismissed with prejudice. Let me also now turn to another piece of information, which is actually the subject of a study that Rachel, Adam, and I conducted along with some other co-authors from our project. So take a look at that second entry, the first blue arrow. It says motion for leave to proceed in forma pauperis filed by Teasley. So here's where just a little bit of domain knowledge can go a long way. That seemingly innocuous Latin phrase there just means a motion to apply to waive certain court fees. So what does this mean? Well, let's take a look at the next slide. It turns out that, as you might think, going to court isn't free. But even if your lawyers work for free, it still costs $400 to file a lawsuit in federal court, which means Teasley had to come up with $400 if he wanted to pursue his petition. Of course, that may not be much for many people or for a large corporation, but if you're incarcerated like Teasley, this can be a substantial, if not total, barrier to the justice system. So what federal courts do is they allow certain indigent parties to apply to waive these fees by filing a motion to proceed in forma pauperis, just meaning in the manner of a pauper. So the application form itself, if you read through it, you might be tempted to think that it's just a means test, like many federal benefits. But first of all, the test is not uniform, meaning the applications for fee waivers differ by district court. Remember, the district court was the lowest court. That means there's 94 potential different procedures for applying to waive court fees. if you can't afford them. And what's more is that even after you fill out the application form, there is no formula. You have to list all your assets and cash flows, and it can be a kind of onerous application. But even after you do that, the decision to accept or deny an application to waive court fees is pretty much entirely up to whichever judge you get assigned to. And it turns out that there's not really a uniform standard that says a judge has to accept the application for any given reason. And legal scholars, as you see here, have studied this problem in some detail, the institutional side. Andrew Hammond, for example, has surveyed the application forms in all of the 94 district courts, and he found that it's basically a free-for-all, even within a state. You see at the top there on the right side, table 1, the application form for the Middle District of Alabama is not the same as the application form for the Northern District of Alabama. And really, one even wonders whether the form matters that much, given how much discretion judges have over whether to grant the application or not. So if we move on to the next slide, we see that, since judges have total discretion over whether to grant a fee waiver, maybe the bigger issue here is figuring out whether there are differences between the standards that between judges and the standards that they're applying. So that's what we ask in our project. We ask, basically, are judges all applying the same standard? And if they're not, to what extent are they not? So here's what we did to answer that question. We took advantage of another little piece of domain knowledge, a key feature of the district courts, and it's a feature that we think many others will take advantage of too, and indeed other legal scholars have done so in the past. And that's the fact that case assignment is randomized within a district, meaning the judge that's assigned to your case within a district, for example, there are 22 in the Northern District of Illinois, which of those 22 you get is as good as random. Now, I've put a little asterisk there next to the word random. Turns out it's not perfectly randomized. There are all kinds of little annoying reasons why it's not. But for the purposes of our study, we concluded that the deviations from randomization aren't something that would challenge our basic statistical inference, but certainly something you want to keep in mind if you're going to rely on this in other projects. So the randomization then enables us to answer a part of the question, right? We cannot compare districts, but since the application, the judge you get, is randomized within a district, we can ask to what extent do the standards of granting fee waiver applications differ from judge to judge within a district. And we do this, if you go to the next slide, by measuring the extent to which each judge's grant rate deviates from the average grant rate of all the other judges in the district. So here's this figure here shows the main result. The graph is constructed by parsing those docket reports, which I've showed you at the beginning, for all cases filed in 2016 across all federal district courts. In those reports, we found about 34,000 applications to proceed in forma pauperis, meaning to waive court fees in 2016. Now, there are just over 1,700 federal district judges, but for visual simplicity here, this figure is just showing the results for about 300 of those judges. These are the judges who ruled on at least 35 fee waiver applications in the year 2016. So for each of these 300 judges, the x-axis is the 95% confidence interval of the difference between that judge's grant rate and the average grant rate of the other judges in the district. Now, because of random assignment, of course, within the districts, if the judge identity really didn't matter and they were applying the same test, then this difference would be 0 in expectation. The y-axis is the percentile rank of that difference across all judges. If the confidence interval does not include 0, then we've just shaded it a darker color of, it looks like teal, I guess, and the lightly colored ones include 0 in the confidence interval. Okay, so again, since cases are randomly assigned within a district, we'd expect 5% of judges to differ from their within district peers at 95% confidence, if indeed they're all doing the same thing. But instead, we find that nearly 40% of judges differ. So the variance within district is way more than what would be predicted if it were just random. The simple conclusion is thus that judges really do matter. They're not all applying the same standard to determine whether to grant a fee waiver application. And in fact, some of these differences are truly substantial. So for example, on the left side of the graph, there at the bottom, the darker shades, we find some judges who virtually never grant fee waivers, even though all the other judges in their district almost always grant them. So this kind of spread, we think, really just seemingly identifies a judge type rather than could possibly be explained by differences, at least random differences, in the types of parties that they see. So before I hand it off to Adam, I'd like to just end by saying that this study I've described just now to you, that's just one study. And it was quite literally motivated by a single line out of the hundreds and thousands of Docket reports, that entry of informa pauperis. You know, if a few of us in the law school see that and say, oh, that's something we could look into. So on the one hand, court records are very difficult to work with. They're pretty much all text. There's no centralized repository. They need to be parsed. They're not well cataloged. Some records, for purposes we could go into later, are actually unobservable, no matter how much money you pay for them. If a judge seals the case or a certain document, you could never have access to it. But nevertheless, we think that with just a little bit of sort of institutional or domain knowledge can go a very long way here in generating new empirical opportunities. And not just for legal scholars, but potentially we think for social scientists across any discipline, across lots of subject matters. And that's of course because, you know, the law and the legal system interacts with virtually every aspect of social and political life. So from crime to immigration, or the behavior of judges, if you're a political scientist or an economist, our hope at least is that by developing this platform and cataloging and analyzing court records, finally, we can offer some new sort of empirical opportunities for everyone. So with that, let me hand it over to Adam, and Adam's going to tell us more about the development of this platform itself.
Thanks, Sarath. As Sarath and Rachel have alluded to, we're not just doing analytical projects here. We are working on building a platform that will enable these types of analyses for everyone. That for us is what we call the Scales OKN. It's the systematic content analysis of litigation events, open knowledge network. And I applaud Laurel for saying that so many times, because when we unpack the acronym, it gets a little bit unwieldy. But at its core, it's very simple. What we want to do is we want to transform the transparency and accessibility of court records and analytics in the public's interest. So we want to make it possible to do these types of systematic analyses and look at individual events that occur during a case and map that back and answer bigger research questions about it. There's a large number of commercial players that exist in the world of trying to serve court records. Most of these would be used if you're a lawyer or law faculty, like Bloomberg Law or Westlaw, Lexis Advance, and more. But there's a lot of real deficiencies for us as academics if we try to ask these broader systematic questions if you were to try to use any of these platforms. And they have two big problems that hamper any of the types of research that we're talking about doing, and hamper even our example with the fee waiver. The reality is that there's really poor availability and no real analytics on any topics that don't make money. So big products like Westlaw or Bloomberg, they don't let you actually download cases systematically so that we can computationally try these questions. Other platforms that do have analytics at a systematic level, like Lex Machina, only have it for intellectual property, because that's one very profitable area where it makes sense to build this up. But for questions that are rooted in fairness and efficacy of the justice system, there's really no lens that's available on the commercial side to try to use and ask that. So that's why we're taking it upon ourselves to tackle PACER and to pull these documents out and turn it into the Scales OKN so that it's actually available as a public data resource for research. Now, unfortunately, the reality is that PACER is a mess. So it's not as simple as snapping our fingers. There's a lot that goes into taking it out from what's really this transactional system and turning it into something that's of real research value, where we can dig into the nitty-gritty details that makes it ready for really peer review level research. A lot of this comes down to the fact that PACER is an operational system that the lawyers, clerks, and judges use every day to actually manage the case. So things can change about the case and then they're updated. Lawyers can be added, they can also be dropped from the case. The case could get passed from one judge to another, depending upon caseload or if a judge retires, and so on. So we need to unpack things like that. But we also have to deal with this bigger problem that there isn't a consistent language in how they actually annotate these events. As Sarath pointed out, there's 94 courts. And each of those courts had their own form about how they would get the information from a plaintiff about whether they would qualify as poor enough to have a fee waiver waived. Well, that same type of inconsistency comes down to how they write. Every judge, every clerk talks about things differently. There are some real keywords that we can rely on from domain knowledge, but there's a lot that we have to do to actually do that inference of what an event is and if it's happening. So in the background, we're spending a lot of time building up our basic ontology of how to tease apart this court record into something that's much more fit for research purposes. We have our docket, and from that docket, we're pulling out that there's multiple parties, that there's plaintiffs, defendants, lawyers, and law firms, and there's also judges. And so we're spending a lot of time doing disambiguation on judges and parties so that we know that Judge John Doe in one case is the same Judge John Doe in another case. Or that the defendant IBM Corp is a corporation and not an individual, and vice versa. So we can ask questions that are at a larger level about, well, what do cases look like if it involves a company, a Fortune 500 company, right? Or just an individual. And then we're building technology that will actually be able to understand what the events are. So if it's a motion for a continuance, if it's a motion to seal a document so that it's not ever going to be publicly available. And importantly, we're working on being able to predict a case's life cycle and where it ultimately resolves. That's actually the question that got me first started in this project, in this collaboration, is when our colleague Dave Schwartz was presenting, and we asked a simple question of, well, how many cases settle? And his answer was, well, we don't actually know. These things are basic facts, but they're not easily accessible right now because it's not explicitly coded. And so we're building algorithms and AI tools to actually do all of us for this so that it's widely available. And of course, we're spending a lot of time and effort trying to identify how we can enrich this data by merging it with other data sources, like the census data, data from the Sentencing Commission, data from the Patent Office, and so on and so forth. We're taking all of this back-end work and we're wrapping it up in a prototype that we're actively testing, something that we will make publicly available to researchers, where the goal is that all of this data is readily accessible to be filtered and searched through with the natural text. And more importantly, we're pairing it with an AI system that knows, given the types of data that's inside of it, what questions can be asked, and allowing you to quickly and easily ask them and get an answer. So you can see high-level statistics very quickly, like what's the average case duration and how is that changing? Or you could ask questions that would be impossible on any other type of tool, like how often are fee waivers granted? Importantly, all of this is possible because this is a community effort, right? What's driving us is this belief that the justice system is supposed to be impartial and equitable, but to be impartial and equitable, it needs to be audited to make sure that the policies are fair. And we mean that in a very broad sense, not just about how the judges use the system, like the example we gave, but also examining how parties use this system, because there's a lot of discretion that parties can use when they choose where and how to file cases or how to proceed in their cases. We also believe that the systematic research should be accessible for the public. Our goal is really to enable researchers to examine the bigger picture and step beyond looking at just one case, really giving the tools to make that transition possible. I would be remiss if I didn't show you how we're doing this. This is actually the broader team, which extends far beyond just the three of us here. We're over 20 faculty members that are actively collaborating on various parts of this. We're from law, journalism, engineering, and social science. And it's through this melding of interests and skills that we're really able to take this project to where it currently is, where we're able to build this type of platform, do this type of data work, and support our community partners like legal aid organizations in their own policy initiatives. And so in reflecting about that, I mean, as a broader question, one of the things that we would love to get input on is, one of the things is, where's the greatest possible potential of where we could take this resource and have it be useful and help improve policymaking? Because there are a number of different merges and places to bring this with other data sources that could dramatically increase its value when it's unlocked. And so with that, I'd like to thank everyone on behalf of Sarath and Rachel, and we'll be happy to take any questions.